Hi, I'm Bill Kristol. Welcome to Conversations. I'm joined by my friend Adam White, who's recently moved from the Hoover Institution to the American Enterprise Institute, where you're, what's your distinguished title here? Visiting resident scholar.
Resident scholar.
Did you have the same high title at Hoover, or was it just a visiting scholar?
I felt
you were a resident scholar.
I felt appreciated at Hoover too.
That's good. Yes. Anyway, AEI has a new program of social, cultural, and constitutional studies, which is great, and you're going to be a key part of that. You've obviously been a very lawyer and a commentator on all matters legal, judicial, the courts and the administrative state, for the Weekly Standard and many other journals. And we had a conversation previously about the courts and the administrative state before the Trump administration began, I think, right? Yeah. But today we're going to talk about the judiciary, kind of an important topic, key talking point of Trump supporters, and maybe legitimately so. And I guess I'd like to begin with sort of 30,000 feet. I mean, if you studied American politics, there was the Warren Court era, and then there was maybe more ambiguously the Burger Court era, which seemed to be sort of the Warren Court stopped doing its thing, but there wasn't much of a counter reaction either, and it kind of, and then maybe the Rehnquist Court, I don't know, or the Anthony Kennedy Court when he was the swing vote, and certain things happened, marriage equality, and certain other things didn't happen, and there was this, it seemed like a somewhat coherent era, I guess, in terms of the jurisprudence. Where are we? I mean, what's the moment? Where have we been recently? Where are we going? What are some of the alternative futures? Let's talk some about that.
Well, for the first time, it really is the Roberts Court. With the departure of Kennedy and the arrival of Kavanaugh replacing him, it's the first time that the court really is under the control of the Chief Justice. First time in a long time, actually. Even before Roberts was on the court, you had Sandra Day O'Connor was the swing vote on the court, and Kennedy after her. So even with Rehnquist and then Roberts as the chiefs, the court really did belong to that swing central justice. And as you noted, for a long, long time, we've always identified the court with the Chief Justice, who really had control, whether it was Warren with a really sort of pretty unified block of New Deal era appointees, and then Berger, a little bit more moderated, but still moving in a sort of a general direction. This really is the first time that Roberts has the opportunity to put his stamp on the court, and I think he's going to affect it in some important ways.
Yeah, so let's talk about that. I mean, sort of big picture, Trump supporters and Trump opponents on the left are very taken by the notion that this is a major consequence, one way or the other, of Trump being president. There are all these judges are being appointed to the justices to the Supreme Court, and I guess judges to lower courts too. Yeah. How big is that? A lot of inside lawyers thinking that who becomes a judge is very important, and if you again looked at it from 30,000 feet, you would say, well, how much is it really going to affect most of these trends in American life, or is this actually? Are we having an important change in the direction of an institution? And how important is that institution, I guess?
Well, as our friend Gary Schmidt once told the New York Times, the Constitution's too important to be left just to the judges and the lawyers. So we don't want to overstate this, but it is important, and especially for those of us who were critical of President Trump as a candidate and now as president, it is, I think, important to concede that he's appointed a lot of judges, not just the two Supreme Court nominees. He's appointed dozens and dozens of judges to the lower courts of appeals, which are really, really important. We can get back to that. And then a lot of trial judges as well. The most important thing is that the Supreme Court, the departure of Kennedy and the arrival of Kavanaugh means that, if nothing else, the sort of steady progression, expansion of rights with respect to abortion, that's probably been halted. I'm skeptical that it's going to be rolled back anytime soon, but sort of this court, I think, will be more sort of solicitous towards state health and safety regulations on abortion. There'll be more room for that kind of regulation. I think this court will be a little bit more moderate on the growth of the expansion of same-sex marriage rights, at least with their intersection with religious liberty and other things, although Kennedy himself sort of began that moderation towards the end of his time on the court. We'll see some changes in those areas of law. We shouldn't overstate it, though. I think the key areas are probably religious liberty, affirmative action. We'll see some on another issue I care about a lot, the administrative state. Those are probably where we'll begin to see actual significant changes.
So let's talk about those some. I mean,
sure.
what and of course we don't know, right? I mean, Trump could have a second term and be followed by another Republican. Right. Elizabeth Warren could be the next president, followed by two Democrats. And so what's really at stake? It sounds like, from what you're saying, that on the social issues about which the courts, in the discussion of which and the resolution of which the courts were so central over the last few decades, and which is so much of the debate about the courts is preoccupied, I don't know, it feels to me, I'm no expert, that not much is going to change one way or the other. I mean, presumably same-sex marriage is here to stay.
Right.
There's some issues around the fringes of sort of how far to go on some further things.
Who's going to be forced to bake a cake for whom, that kind of thing.
Right.
Yeah.
And then on abortion or the right to life issue, I guess Roe could be overturned, but even if it were, some number of states would keep abortion legal. So in the real world, it seems to me, of, let's say, sexual morality and gender roles, it doesn't sound to me like the courts are going to be major players over the next 5, 10, 20 years. Is that?
Well, that could be it. If that's true, that's a change in and of itself.
So that they've stopped being a sort of major force in one direction.
Yeah, I think that's extremely important. And I wrote one of the last pieces I wrote for the Weekly Standard, actually. It was about the fact that the departure of Kennedy, as I called it, the end of Justice Kennedy's Camelot, it wasn't that we'd see a rollback of these rights, but the left could no longer count on Justice Kennedy as a pretty reliable sort of leader of the court in a steady leftward direction. So we'll see, like I said, we'll see the court sort of put some limits on some things, open the door up to more federalism on issues like public health and safety regulation. But then we'll also see sort of a counter move. Groups that would normally challenge state abortion laws in federal court under the federal Constitution, they will probably start to look more at state courts and state constitutions. I think one of the biggest changes the next 20 years is going to be a pretty big rediscovery on the left of state constitutional law. This is something that actually Justice Brennan called for, I think in the early 80s. We're going to see a return to that. I think suddenly we'll see a strange new respect for federalism when it comes to state constitutions and state courts. We saw that actually not long ago from my home state, Iowa. The state passed some new laws regarding abortion, and the challengers, they stayed out of federal court. They didn't invoke the U.S. Constitution. They went to state court.
The laws were restricting.
That's right. They were restricting abortion. Yeah. And the challengers, I think it was the ACLU and Planned Parenthood, I might be wrong, they went to state court under the state constitution. And I think we'll see more of that, especially on issues like abortion, where if the left is convinced, and again, so much depends on what happens in the next election and the next few years of judicial appointments, but the more that the left becomes convinced that the courts are no longer a hospitable forum for the issues they wanted to make progress on, the more they're going to move to state court under state constitutions whenever possible.
I mean, that's interesting, because you'd have the ironic, but the effect then of red states becoming more red state-like, perhaps, because presumably those courts, indirectly, if they're elected, or indirectly, if they're appointed by governors, reflect the politics of those states. Red states becoming more red state-ish, and blue states becoming more blue state-ish in terms of even the courts, right? I mean, that you could actually have different jurisprudences, sort of, in different parts of the country on some of these issues, I suppose.
Now, even in red states, when it comes to state Supreme Court selection, oftentimes the selection process is really tied into the bar or the court infrastructure itself.
So less.
It might actually, red states might be less red when it comes to the to state constitutional law, and that could be a real advantage for the left when they go into court. Now, a lot of issues will stay in the U.S. Supreme Court, of course.
So let's go through the ones you mentioned. So, I mean, religious liberty seems to be one that is very, was very front and center in the late Obama administration, a couple of very big cases. Certainly very big in the rhetoric of 2016 with Trump, and more muted, I guess, on the other side.
Yeah. A
lot of strong feelings about that. Where does that go, do you think?
So in the last few cases under, we'll say, the old court, we saw the fights over, I guess it was Masterpiece Bake Shop, the bakery that was being required by the state of Colorado to bake cakes for a same-sex wedding. And then we saw the collision of Obamacare and religious liberty a couple years earlier. And so that's a matter of religious liberty. It's under, at least at the federal level, what we call the Religious Freedom Restoration Act. That was supposed to strike a balance, restrike the old balance between religious liberty and just general neutral state or federal regulations. We saw an interesting move coming from Justice Ginsburg and others in these cases, where they wanted to interject a new consideration of the balancing test. They really wanted to put front and center the impact of somebody's religious beliefs on the rights or interests of third parties. So that the baker who didn't want to bake a cake was in effect imposing his religious beliefs on the personal moral beliefs of the couple that wanted to get the cake. At least that was the argument. I'd say that the arrival of the new justices means that argument is probably unlikely to prevail now, which I think is important. It would have been a significant recalibration of religious liberty and the Religious Freedom Restoration Act to add in this special new focus, sort of a trump card on religious liberty claims anytime some third party's rights were affected, whether it was an employee who wanted contraceptive coverage in their insurance, or it was a couple that wanted a cake for a same-sex wedding, or anywhere else where somebody's invoking religious liberty sort of in the marketplace.
So you think religious liberty gets more
it gets
thoroughly protected?
Yes.
No one's going to make priests or rabbis do things they don't want to do in terms of marriage, or doctors do things they don't want to do in terms of procedures in hospitals and so forth. I mean, no one, but I mean, the tilt will be more towards respecting people's religious views and wishes to not do A, B, or C.
Right, and it might seem like a small thing, but it's actually very important. I think it had a lot to do with a lot of the energy from conservatives in 2016 who weren't big fans of Trump, but who thought the court with the Justice Scalia seat open was an incredibly important issue to vote on. You saw just a year or two earlier in the same-sex marriage litigation where President Obama's Solicitor General, was asked in the Supreme Court case, if we recognize a federal constitutional right to same-sex marriage, does that mean that nonprofit organizations that are critical of or opposed to same-sex marriage, will they lose their tax-exempt status? And the Solicitor General, who surely was asked this question in prep sessions, kind of shrugged and said, I don't know, that's a really good question. That terrified a lot of people. And I think the reassurance that there's going to be that the court will be more hospitable towards free exercise of religion claims, the rights of nonprofits that are critical of some of these rights. I think that is going to be a significant shift in where the court could have gone under President Hillary Clinton.
I mean, I suppose not exactly counter-argument, but the qualification of that might be, again, if you're sort of more of a political scientist or social observer, let's just say, and not a con law specialist, that sounds right, and that will certainly moderate. It's certainly different from the way it would have gone with a Democratic president. But big picture, again, 30,000 feet, status of religion in America, does it really, how much these court decisions do seem in some cases to be, maybe this is a little misleading, but they seem to be sort of on the margins, and it's, one private company which doesn't want to provide this insurance, and one bakery. We're not talking about the big picture kind of religion in the
Well, we could be
but maybe we are. I mean, I guess that's the question.
We could be talking about Catholic hospitals, Catholic adoption agencies, that whole sort of infrastructure of social services in cities, towns, states, that has sort of existed under government regulation, but has very strong moral components, especially, again, the church-affiliated organizations.
And you think those will tend to be protected?
Yeah.
Even if, that's interesting.
Yeah.
That's interesting.
Yeah, I think
they may choose under social pressure and cultural pressure, I suppose, to not insist on certain things, obviously. Right.
Yeah. I mean, more than anything, I think one of the things that fueled the sort of Flight 93 election fears of a lot of people on the right was this concern about using the federal administrative state, fueled by a particular progressive ideology, to really come down heavily on institutions like private companies, nonprofits, who are just out of step with those cultural colleges.
So how much is those that take colleges and universities, which I know a little bit about? I mean, there the federal administrative state came down heavily, I would say, on one side with Title IX regulations and that letter in 2011.
Yeah, the Dear Colleague letters.
Yes.
Yeah.
Now, is it unreasonable for the right, though, to think that, is it reasonable for them to think we need to control the education department to prevent such letters from being sent and to get them somewhat rescinded, as has happened under Trump? Or can they say, well, the courts will probably stop that kind of stuff from happening? That's how much will the courts affirmatively step in as opposed to simply allow a Republican appointee to not go as far as a Democratic appointee?
Well, just to be very clear, when the Obama administration sent out those letters to colleges saying you need to recognize these rights of victims of sexual assault, people who wanted to use the bathroom of their choice, the administration was pushing on an open door there. Right, the colleges were very happy to comply with these things, and the change of administrations, change of courts isn't going to change that. And I'd say in the future, the next Democratic administration, if they want to pursue those policies, they'll do it. I think they'll do it in a smarter way procedurally. I don't think there's a whole lot the courts are going to do to intervene there.
So in that respect, big social trends don't get stopped by a few judges. And
that's right. The court doesn't create social trends. although it sometimes can help them along the way. It doesn't stop social trends. It just can moderate and modulate the ways in which they actually are achieved through public policy.
So moving through some of the other big
Like
areas.
affirmative action.
So race and affirmative action. Certainly, if you write a history of the Supreme Court over the last 75 years, you would say race has been a major both achievement and controversy and so forth of the federal courts. Now the question, I suppose, is less further advances of civil rights. I mean, to use, I don't mean to demean it. I'm just saying from one point of view, as opposed to, moving back in the other direction towards colorblindness and so forth. Where does that go, do you think?
So for the last several decades in the Supreme Court, the affirmative action question has always been up for grabs. Case after case, it wasn't clear where the court was going to come down, in large part because of Justice Kennedy. This is an area where his departure makes a real difference. If his replacement, Justice Kavanaugh, turns out to be a steadier hand on either side of the issue, I think at least we'll get some more predictability. And it comes at an important time. As you know, your alma mater, Harvard University, is facing a significant federal lawsuit over its affirmative action policies, its treatment of Asian American students and student applicants. And
Did you go to Harvard Law School? I mean, it's like suddenly it's my alma mater when they're getting sued for, for bad behavior. But that's okay. That's okay. But it was the college.
Harvard Law School is
it's not really.
It's
Harvard.
It's
that's
not,
right.
Let's
be honest.
And you'd be the first to point that out.
Totally.
But so Harvard is facing a tough case there. The record in the case was really ugly. The documents that had come out from inside the admissions policy, that really proponents of affirmative action really could not have. They couldn't have a worse case. I think this is going to be an incredibly important case. Who knows how the trial judge is going to rule? It's been pending for a little while. Who knows how the Court of Appeals is going to rule? But this really does seem like a vehicle to make significant change on affirmative action law. And specifically, whether the 14th Amendment's protection of equal protection of laws, whether that blocks this sort of treatment of Asian Americans in the admissions process, and perhaps pushes us further towards what Chief Justice Roberts called for, a colorblind constitution on university admissions policy. So that, I think, could be a very significant change.
So despite all the social and cultural momentum towards diversity, which is what affirmative action sort of morphed into in some ways, in other ways it's its own thing, but you think the courts really could move against that, at least where it clearly is disadvantaging people partly based on race or ethnicity? Yeah,
I think so, especially when some of the documents that came out from Harvard were just so really eyebrow-raising, really astonishing in how Asian American students were being disadvantaged. I think that we'll see at least significant movement on the treatment of Asian Americans in this process, but once you begin that conversation, it's hard to see where you draw lines without really moving towards a colorblind constitution.
And does one move towards that, not just for the public sector, but I guess Harvard is the private sector, but for the private sector, not just for universities, but for hiring and other things?
That I think will become murkier, but definitely with universities and their obligations under federal laws, in addition to state universities under the federal Constitution, I think we'll see some movement.
Interesting.
Yeah.
Where else would you sort of put a spotlight? I mean, the other issues that have been so big over the last several decades are what? There's crime. I mean, that was very big. In my youth, law and order, judges, I have the vague sense there's not that much being resolved one way or the other, that criminal justice policy is not centered in the federal courts anymore, and that it's pretty, am I wrong about that?
Well, you're seeing some criminal justice issues in the form of search and seizure and new technologies. Right, what does it mean for the police to obtain your cell phone records of your location from your cell phone company, tracking car movements, that kind of thing? I will say, on these issues of criminal law, this is an area where the conservative coalition on the Supreme Court really breaks down in interesting ways. Justice Gorsuch seems much more libertarian. He has moved with the liberals on the court to declare a couple of criminal laws unconstitutional because the laws are too vague. It's called void for vagueness. It's kind of a criminal version of the non-delegation doctrine. We've seen Gorsuch move there where other conservatives weren't. Justice Alito, meanwhile, has always been sort of more deferential to the practical needs of law enforcement. Having been a federal prosecutor before, I suppose that's no surprise. So that'll be a place where you can get some interesting coalitions between the right and left on some decisions. But I agree with you. Criminal law is probably less important. What I would point to next, my other area of focus, is the court and the administrative state.
So let's talk about that. But the administrative state went from being something that you and Christian Muth and 12 other people argued about at George Mason Law School and AEI and Hoover and Hudson to think tanks to a huge, kind of a big term thrown around in 2016. I'm not sure if people really knew what they meant by it.
Yeah.
And so, what will the courts curb the administrative state? Are they part of the will they increasingly? Well, explain what's likely to happen there?
I think this.
What has happened there? I
Well,
guess.
the first thing that's happened is the appointment of 2 Supreme Court justices. And if you look at Kavanaugh and Gorsuch, it's pretty clear their main qualifications in terms of their record for getting on the Supreme Court was their focus on the administrative state. Both of them, Kavanaugh on the D.C. Circuit, Gorsuch on the 10th Circuit out west, both issued a number of opinions where they were critical of some Supreme Court doctrines of deference to administrative agencies, broad delegations of power from Congress to the agencies. Now, when you're on the lower courts, you're not in a position to change the doctrines, although you can sort of hem them in a little bit. And I think both of them were picked in large part because of their views on the administrative state. And by the way, that's also true of a lot of the lower court nominees. The selection process for the justices and judges really was centralized this time in the White House with White House counsel Don McGahn. This has been a major issue for him, the administrative state. He used to run the Federal Elections Commission, so he's seen it up close. And so I think we'll see some significant changes on issues like deference, where we saw in the last Supreme Court term a little bit of recalibration on that. There's going to be questions about this doctrine. I won't bore our audience with it, but it's called Chevron deference.
I've always been a big fan of publishing articles at the Weekly Standard on Chevron deference.
I published a few of those.
We had to change the headline though, so people might actually read them.
Yeah.
Really, are we deferring to some oil company? Or that was a case where there was a Chevron versus someone, I suppose. I can't remember who they were suing.
The EPA got sued. Or the EPA got involved in a lawsuit against Chevron. Yeah, deference to oil companies, that was actually the Bush foreign policy.
Yeah,
right?
Good point, yeah. And so the deference was, but just to clarify, the administrative law issue really at its heart is...
Yeah, the issue is when Congress
what constraints are there on the executive branch and the administrative agencies in just broadly interpreting laws, broadly administering them, changing their mind, being arbitrary, right? This whole gamut of things that a big government can do and sometimes does, right?
Right. When Congress writes a vague statute, and that's almost all statutes, the question is, who's going to decide what that statute means? A judge or the federal agency that administers it? Now, for a long time, dating back to the 80s, the conservative view, the Scalia view, was we need judges to be deferential to the agencies, to leave room for the elected president and his appointees to make policy within the limits of the statutes.
And Congress could step in to fix it. The elected representatives could step in to fix it. So this was sort of a piece with judicial restraint of a certain kind.
That's totally what it was. And about 8 years ago, you had folks like Justice Thomas, scholars like Philip Hamburger, even Justice Scalia a little bit towards the end, saying maybe the deference thing has gone overboard. I mean, Thomas and Hamburger and others said it's definitely gone overboard. It's inherently illegitimate. Judges shouldn't defer to anybody. But even conservatives who were proponents of deference thought maybe this stuff's gone overboard. And so I think there's definitely a movement among conservative judges and law scholars to recalibrate these things, make judges as my new colleague at AEI, Peter Wallison, says, we need more judicial fortitude, a line from Federal 78. The judges need to decide more and defer less. Another question, and this was also the subject of a case, it's going to come back up soon, I think, another case involving what we call the non-delegation doctrine. If Congress passes a statute that really is open-ended and doesn't really put any limits on an agency, is the statute unconstitutional? Has Congress just given away its legislative power? That doctrine has been floated for about 200 years. It's really only succeeded in a small handful of cases, most of them about 80 years ago. But we're now seeing sort of a resurgence of that doctrine and a call from judges and scholars and lawyers to revisit this. The next case that's going to come up involving this is actually a challenge to President Trump's national security tariffs. There's a law professor at George Washington, Alan Morrison, definitely not a conservative, who's saying that those statutes violate the non-delegation doctrine and they should be struck down.
But that's Trump gets to say anything's national security and that he slaps a tariff on something that doesn't seem like it's a classic national security emergency, right?
Right, right.
So many cars are coming from Germany or something.
Yeah. And then in addition to things like deference and delegation, there's just the process of agency lawmaking. That's something where you can see the court becoming more skeptical, requiring agencies to be more transparent. The court could say that laws like the Administrative Procedure Act actually require more of the agencies than the agencies are now doing.
Not just some vague base. If there's any excuse for it,
right?
It's legit. What's that called? The rational basis.
Yeah.
I mean,
rational
insisting
basis,
on more of an actual
right.
basis, you might say.
Right, and more participation in the process, real notice and comment rulemaking, and so on. So it's pretty procedural stuff. And again, it's not that they're going to strike down a lot of policies. They're going to block a lot of policies. It is just recalibrating the pace at which policy can be made, which is important in a time when the public is pretty divided politically. And in every presidential election, there's a chance that the other party might regain control of the White House. And Congress isn't legislating that much. It means that every administration you have this race to do as much as you can in policy through executive orders, through agency rulemakings, and so on. And so agencies have more and more incentive, more and more political need to move quickly. And so this changing of the guard at the Supreme Court and the lower courts, where a lot of the nominees, the appointees were focused on these issues, I'd say it could have a significant effect on the pace of policymaking and really slow things down.
But not so much, it sounds like, on the actual size of government
right.
and the administrative state. We're not talking about, thanks to the conservative appointments on the court,
right.
this big government's going to shrink a lot. We're
right.
talking
They're not
about the way it functions could
right.
be more orderly, more predictable, more in accord. Some things Congress might be forced to specify certain things, make choices, as opposed to simply toss the ball over to some agency and so forth, right?
Yeah, when Steve Bannon said that they were going to deconstruct the administrative state, and then it deconstructed him. It's not deconstructed. It's still there. I see it outside my window every day. The court isn't going to take it
Congress
away.
could do that, but not the court, right?
Yeah, that's right.
I mean, in theory, could do it.
Yeah, I think some people would love to see the court suddenly declare the FTC and the Department of Education and the Federal Reserve unconstitutional. It's not going to happen.
It sounds to me, listening to you, though, that the debates I grew up on, and were still very vigorous when I was in college, grad school, judicial activism versus judicial restraint. Those are very huge terms, and really made it all the way into the mainstream political discourse, obviously.
Yeah.
That doesn't seem to capture the current moment. I mean, that this conservative, quote, conservative position is sometimes for restraint, don't impose, national social mores on the country. Let's say legislatures govern. Mm-hmm. But sometimes for a kind of activism, don't just step aside and let these agencies do what they want. In the religious liberty case, I'm not sure if it's activism or restraint. It's sort of activism on behalf of religious plaintiffs against, let's say, state, either legislatures or bureau administrative agencies that are sort of ignoring certain rights. I mean, so am I right that the restraint activism thing is not the line anymore, or is it still a fundamental sort of distinction?
Well, in some ways it's flipped, right? After a few decades of the Warren Court, the Burger Court, and the Anthony Kennedy Court making law, the calls for judicial restraint come increasingly from the left, right? Calling on conservative judges to respect precedent, to not strike down too many laws. So really calls for judicial restraint of a sort come a lot from the left these days. On the right, there's a pretty interesting debate happening now among a large segment of conservative lawyers and conservative judges who call for what they call judicial engagement. They avoid the term activism, judicial engagement, the idea being that courts should be much more assertive in either recognizing unenumerated rights that aren't spelled out specifically in the Constitution, but their advocates say are contained within the Constitution's protections of liberty. Or you see, related to that, people who say it's not so much about rights, it's more about judges needing to be much more assertive in forcing the government to justify its policies, to show more facts that support the policies, show how the facts really are tightly connected to the policy or the outcome the policy purports to achieve, sort of to put the political branches of government on trial every day and have them prove their innocence. As you can suspect, the way I teed it up, I'm skeptical of this. I think that's asking too much of judges, too much of courts, and making a lot of the same mistakes that the left made with courts. But I'd say right now in the conservative legal movement, a lot of most of the intellectual energy is on the side for more judicial engagement, less deference to Congress, less deference to agencies, less deference to even city councils and so on, and putting judges front and center on reviewing the work of the political branches.
And do you think that moves from the law schools to the actual judges and justices who have been appointed,
Yeah.
or do they shy away from that because they're actually on courts and they sort of look around and think, am I supposed to get in the middle of this fight,
Well, hopefully the experience of being put on a court will moderate them a little bit in that respect. There are plenty of judges who really do embrace the idea of judicial engagement. Justice Thomas doesn't use the term, but I think he is probably the ideal in this respect. A very strong originalist, very confident of the court's work in overturning old precedents that don't line up with his reading of originalism. Whereas other justices like like Scalia might have left more room for precedent, or Alito might leave a little bit more room for experimentation at the state or local level. Justice Thomas seems to be the most confident in originalism and the least patient with precedent. There are some lower court judges. Don Willett on the Fifth Circuit, one of Trump's appointees, has been a leader on this, and there are others. I'd say very few judges are going to wave a flag that says judicial engagement, but I do think there are judges, a lot of the ones who have been appointed, who are more who are interested in re-engaging the courts on some issues where they might have been more deferential.
I suppose originalism, when that became the kind of banner as opposed to restraint, under which conservatives sort of marshaled against liberal activism, always had the potential to go in this direction, right? Because if you're interpreting the original meaning, and you can overturn a lot of precedents that misunderstood the original meaning, even if they've been going on a long time.
Right. The old speeches by Ed Meese in the 80s when he was Attorney General, they were about original intention as a tool of judicial restraint, as a shield for the political branches to actually make policy and govern and not be governed by judges. At some point, the shield becomes a sword, and you start to look around and say, well, what state laws, what federal laws should be struck down? Now, of course, that's not new. That started in the 90s, really, in the federalism cases, where they were striking down some federal statutes as being unconstitutional. Well, I think we'll see more and more of it, and I think, again, we'll see judges, this new generation of judges is less patient with some of the deference doctrines that kept judicial review a little bit more moderated.
I guess one other area where there are disputes between right and left, but I guess within right and left too to some degree, is some of these more directly political areas where the courts have been called on recently and have actually had cases on things like redistricting, reapportionment, which I think people would have thought once, it's like, ooh, the courts can't really get involved in that. Many people would have thought. But now there's some sentiment, seems to be broader sentiment maybe, that the courts need to step in where the political process is somehow just dysfunctional or tilted in one way, or for some structural reason.
Yeah, so there have been cases in the last few years over things like the Voting Rights Act and the Justice Department's power under that law to sort of govern the state's redistricting process. But the most significant case, it was just decided at the end of the last term, had to do with gerrymanders. Not gerrymanders based on race or other things, but gerrymanders based on basically just partisan calculation, right? In a day when people who draw these districting maps, they can get out their computers and draw districts that are perfectly drawn to maximize the advantage of the political party that's drawing the map. There's real frustration with this. If you're in a red state, there's frustration on the left, and if you're in a blue state, there's frustration on the right. And so in the last Supreme Court case, there were a couple of cases that went up. This last Supreme Court term, there were a couple of cases that went up calling for the Supreme Court to strike down what they called partisan gerrymanders. The court said no. The court said this looks like a real problem for democracy, but it's not the kind of problem that the court can fix, because there isn't a rule in the Constitution that we can apply. The challengers in those cases were calling for standards, almost mathematical equations, that if a party's power in the legislature grew, if its majority in the legislature grew too big beyond its just voting majority among the voters, that at some point the court should draw a line and say that's the result of a partisan gerrymander. And the majority of the court just said, no, we can't do this. There's no rule for us to apply. In a way, I'll say there's an interesting connection between that and the issue of non-delegation. Right? In non-delegation, conservatives look at the issue and they say, Congress isn't doing its job anymore. It's given away all of its powers. Congress itself won't fix the problem. We need the courts to come in and draw a line between statutes that are just kind of broad and statutes that are unconstitutionally broad. And conservatives made that argument, and the court has consistently said, that might be a problem, but it's not a problem we can solve. There's no line we can draw. I think the gerrymandering issue is the same thing. It's the left's version of the non-delegation doctrine. Complaining about this breakdown in the redistricting process, the fact that partisan state legislatures are never going to fix the problem themselves. They are the problem. And so the court needs to intervene and draw a line. And the left was disappointed in those cases. The court's answer was the one that the court has given to conservative advocates of non-delegation. This is a problem, but it's not a problem where there's a line for us to draw. And
now, some lower courts did step in, right? And so I suppose maybe there's more appetite. They can do some of that. I guess it can get appealed to the Supreme Court, but and maybe those are state courts in one or two cases. I can't remember, in Pennsylvania or something. But anyway,
I can't remember. It's maybe a mix, but that's been an interesting theme in and of itself of the last few years. Has been the federal trial courts, federal trial judges jumping out quickly on issues like redistricting, or Trump executive orders on the travel ban and things like that. And the Supreme Court, time and time again, has told the lower courts to calm down. Has the courts even sometimes issued orders blocking the enforcement of lower court orders until the Supreme Court could review the things.
So which is the wave of the future there? The Supreme Court telling everyone to calm down, or some lower court saying, yes, we can't permit this travel ban? I mean, it did seem for a while there early in the Trump administration that the judicial activism was back, like it or not, like the travel ban or not. Yeah. It was certainly kind of back in spades. Some district judge I'd never heard of is suddenly stopping it nationwide, something the president wanted to do,
Yeah, I mean, who knows what's going to happen with the lower courts? I think the Supreme Court, in its current state, and of course it could change, and I'm sure we'll talk about that, this court seems to be of a mind of having the lower courts slow down on these things. And you've even seen Justice Thomas and others call for maybe rethinking this nationwide injunction issue. How is it that one trial judge can just get a federal lawsuit before him and just issue an order blocking policy nationwide, even on something like immigration? So far, the court has been skeptical of those moves. Even where the lower court might be right on the merits of an issue, the Supreme Court has really counseled for patience. And I think that's actually probably a good thing.
How important are the lower courts? We talk so much about Kavanaugh and Gorsuch, and of course, is it a Roberts Court and all, and that's very important. But some people say, look at what's happening at the appellate level and the district court level. That's really a big change. And
this is hugely important, actually. President Trump's been in office now almost 3 years. In addition to his 2 Supreme Court nominees, he's appointed over 40 judges to the federal courts of appeals and dozens and dozens of judges to the federal trial courts. There's only a couple of hundred federal appellate judge seats in the country. He's already changed about 20% of the judges. He far outpaced his predecessors in these Court of Appeals seats.
I guess having a Republican Senate helps.
And
a Republican Senate that blocked President Obama in the last couple of years, right?
And a Republican Senate who inherited from Harry Reid the elimination of the judicial filibuster.
Good point, yeah.
But so what's the point of having these judges, or what's the impact? It's huge for a few things. One is the courts of appeals are effectively the Supreme Court for most cases. Most cases don't go to the U.S. Supreme Court, so the Federal Court of Appeals is the last word on some significant issues. Second, even for the cases that go up to the Supreme Court, they first percolate through the lower courts. And in that process, having good, thoughtful judges, originalist judges, chewing on these issues, refining the issues, finding the best arguments, and sort of embrace and endorsing those arguments, the best version of those arguments, is going to improve the quality of advocacy in the Supreme Court. I think it's going to improve the quality of Supreme Court decisions, just because the issues will be improved by the process below. And then last but not least, these judges appointed to the federal bench and the courts of appeals, they become the bench for future Supreme Court nominees. And so the quality of judges that Trump has appointed has been really incredible. Some of the judges on these courts, people like, my friend and your former employee, Naomi Rao, on the D.C. Circuit, or Andy Oldham in Texas, or Amy Coney Barrett from Notre Dame, who's now on the Seventh Circuit. These are judges who now are in a position to not just decide cases, and further sort of elaborate and refine originalism. They could be the next Supreme Court justices, and it's a great bench to choose from.
And how much do you? So let's look ahead now. I mean, Trump and McConnell played this card in 2016. They've governed as they said they would, and great accolades from the conservative parts of the conservative legal community. Great worries from a lot on the left. Do we now expect every 4 years for the courts to be even? I mean, they already were front and center, but to be even more front and center, and especially, I suppose, in 2020, where it does seem like 2 terms of Trump would make an awful lot of difference as opposed to 1 term of Trump.
You know, the 2016 election really was the perfect storm. The court wasn't just divided, but you had the passing of Justice Scalia in the middle of the election process. It's hard to imagine the court being more front and center than it was that time. That said, I think...
And you'd had Obamacare and same-sex marriage
right,
within the last 4 years, both genuinely major headline-grabbing moments for the Supreme Court, both 5-4, I suppose. Right?
Yeah, and conservatives very worried about what the next wave of cases was going to bring on issues like, the collision of same-sex marriage and religious liberty. President Trump's use of a list or lists of possible Supreme Court nominees, that innovation, it'll be interesting to see what comes of it. I think among conservatives, it's hard to imagine that not being a sort of a new institution in our politics. Republican nominees coming up with lists of the judges that they would appoint. It'd be interesting to see whether Democrats do that. They obviously haven't done it so far in the primary process. Maybe the politics aren't quite the same for them and not pre-announcing their judges. I don't know. But I do think that move by President Trump is going to have real ramifications for Republican candidates and for conservative judges.
And for judges, don't you think? Because it feels to me like, one reason for that was that conservatives were so disappointed by some of the Republican presidential appointments.
Yep.
Justice Souter most famously, but others as well, Justice O'Connor to some degree. The attempt to have Justice Harry Meyer become a Supreme Court judge. So I guess the left doesn't get disappointed that often, so maybe they don't feel as much need to have an actual... Because I think one point of the list, wasn't it, was to reassure the Federalist Society and everyone else who's interested in this that, you don't have to trust me, Donald Trump. I might have, God knows, he could have some flaky idea about putting someone on. Here's the list that basically you guys submitted to us with a couple of, emendations, and we'll pick from it. And he has picked from it, and it seems like I don't think there were literal lists for the lower courts, but he's basically, wouldn't you say, done the same thing. I mean, he's followed let's call it the Federalist Society consensus close enough in most cases as to who would be the appropriate people to put on the different circuit courts and so forth.
There's always, with judicial appointees, especially to the lower courts and the trial courts, a lot of it is always going to be based in large part on the senator for that state, the senators having sort of their favored candidates, and the local bar and so on.
But less so, I think, with Trump, right?
But
At the appellate level, I would say those people are more national stamp of approval from conservative law professors than, the kind of traditional local big shot who, is head of the local bar association and is a good friend of the senator. That would be the old-fashioned way.
Yeah, we conservative law professors wield immense power. I'd say it was Trump and Trump's first White House counsel, Don McGahn. I think that's key, is that Don McGahn cared about this issue. He brought the judicial appointment process out of the Justice Department, out of the Office of Legal Policy, and really put it in the White House counsel's office. So he had much closer sort of centralized review of nominees. Now, it is true, I think, that this crop of judicial nominees definitely includes people who were, well-known in Federalist Society circles, conservative legal circles. So I do agree. I think that this crop of judges is of a more sort of national standard, and that's important. think that's important.
But anyway, in 2020,
Yeah.
so what is so I guess the conservative, assuming Trump's the nominee, it'll be, I'll do more of the same.
I'll do more of the same, and he'll say, don't let them pack the court.
And so what will the left say? What is the left saying? I think we all know what Democratic candidates are saying, which is not that much in detail yet, but what are influential legal academics, the equivalent of their federal society, saying about this? What's their vision going forward? I mean, I guess both in terms of actual appointment nominations, but also in terms of more philosophically, in terms of what's the liberal court agenda.
Well, so the reason why I paused there was that I don't know what the sort of consensus is. I don't get invited to many of their meetings, but there are loud voices in those circles calling for Congress, the next Democratic president with a Democratic House and Senate to expand the court as payback for blocking the Merrick Garland nomination under Obama, payback for confirming Kavanaugh in light of the allegations against him, and reclaiming the court, lest it lose. And the way they would frame it as, we need to do this to maintain the court's legitimacy. And maybe we'll get back to that. The argument over the court's legitimacy, I think, is important. But you're seeing calls on the left to expand the court. And I have to admit, I look at that and I wonder if they're trying to repeat 2016, right? I said a minute ago that Scalia's passing I think I said a minute ago that Scalia's passing put the issue front and center in 2016.
And McConnell keeping the seat open.
Well, if 2020 is an argument over whether Democrats will create 3 or 5 new seats, it puts the court front and center once again and creates a plausible, I hate to say it, but Flight 93 election narrative in the hands of the Trump campaign, who'll say, you elected us to protect Scalia's seat. Now you need to protect us from the 3 or 5 seats that would go to, and then just fill in the blanks of 5 left-wing judges or law professors. It's unfathomable to me, first of all, why the left would toy with this idea as just a matter of policy. But second, why they would do it so openly in a campaign year seems totally self-destructive.
Well, they're competing among themselves.
They're trying to outbid each other. That's right.
Yeah, but you'd think the way to win back reluctant Trump voters would be to, in effect, without quite saying it this way, look, you did get some reassurance on the court.
Yeah.
These people aren't going anywhere, most of these conservative appointees. They're pretty young. So we're going to have a balanced court. Obviously, if an elderly liberal judge dies, the Democratic president's going to appoint, or retires, resigns, a Democratic president's going to appoint a liberal. Mm-hmm. But it's not going to fundamentally flip everything over one way. That would be a reassuring message to swing voters, you would think.
Yeah.
But it's not what the activists want to hear.
That's
and
right.
It's not what they believe, really, I would say. There's a fair amount of indignation about McConnell holding the seat open and other aspects of the Kavanaugh hearing, obviously, the Federal Society's role, the whole thing. So
yeah, there is sort of remember the Alamo aspect to all of this, the Garland seat especially, that what McConnell did was fundamentally illegitimate, and it delegitimized the Gorsuch appointment. Gorsuch ultimately filled that seat, and then when you add on top of that just all of the controversy around the Kavanaugh nomination, I think they see this as a matter of principle. And I'll say, though, even if they tried to reassure, even if a Democratic nominee tried to reassure moderates about this, the fact is that soon conservatives will start to look at Justice Thomas the way that liberals look at Ruth Bader Ginsburg. A great justice who probably needs to step down on their own terms before health takes over. Justice Thomas has been on the court for a very long time, and I hope he's there for a very long time. But at some point, you'll start to see calls on the right for Justice Thomas to step down so that a Republican president can appoint his successor.
And of course, these things are unpredictable.
Exactly.
Justice Scalia was a friend of ours, and was some good health and had a heart attack, and so no one expected there to be an open seat in 2016, and then McConnell succeeded in keeping it open. And I do think that's underestimated as I don't know if it's a real reason, a rationale at least, for very reluctant, swing Republicans, moderate Republicans, upper middle class Republicans who didn't like a lot about Trump, to sort of swallow hard and vote for Trump. If there hadn't been an open seat, you still could have theoretically said, well, it's going to be very important over the next 4 years. There'll surely be an appointment or two.
Right.
But having the seat there front and center is so dramatic. And of course, that who knows about people's health and all that, but of course that could happen this year, or someone could step down, as you say, and
again,
on either side, and so you could have the court really in the middle of the political fray, and pretty quickly, actually.
Yeah, and again, even if there isn't an open seat,
it's
a debate.
It's been so. It's been central in the last few years that you think, people
right, but also
forget about it.
A proposal to pack the court creates 3 open seats. Right.
But even without that, don't you think it's been so headline grabbing?
Yeah.
Gorsuch, Kavanaugh, these decisions. I mean, that it will be more of an issue, I would guess. I'm making, in the presidential debates, they're more likely to get a question.
Yeah.
What's your vision for the court? What's your vision for a good justice? Then maybe they always got that question. It was sort of routine. It was kind of half the time. It was kind of pro forma almost. You knew you were supposed to ask a presidential candidate what criteria he would use for appointing Supreme Court justices, because that's what presidents do.
Right.
But I do feel like now you'll actually have it raised in speeches by Trump, and if he's the Republican nominee, and whoever the Democratic nominee is, as a kind of affirmative agenda item for each of them, which has been less common, I would say.
Right, and Trump is going to be able to say, I will continue to appoint judges like Kavanaugh and Gorsuch. The Democratic nominee, I don't know how he or she answers that question. Right? Do they say, I will appoint somebody like Ruth Bader Ginsburg?
Yeah.
Do they? Do they say, my guess is they'll say, I'll appoint somebody like Elena Kagan, who's been a little more moderated, who has...
I think you're too close to it. I mean, I think she's a total heroine on the left. I mean, justly or unjustly.
I wouldn't disagree with that, but I don't think
and not
she's
just
seen,
on the left, but even among sort of independent types. Well, who knows? Whichever one they say, the point is, what will they... I mean, how much will they promise that the court can do, I suppose? That's an interesting question for me on the left. So let's talk about the left a little bit.
Yeah.
Did they have, I mean, if you're an intelligent, and we can ask them, and I have asked them, but from your point of view, if you're, a thoughtful person who believes in various liberal causes, income redistribution, strict interpretations of gender equality, diversity, worried about various aspects of American history and life and making up for that, how much are you counting on the courts to help resolve these issues in your favor? How much are you just counting on the courts not stopping you from doing certain things? I mean, where would you say the courts stand in the liberal imagination today? I mean, certainly when I was in college and grad school, they were front and center.
Right.
Earl Warren was a hero, and Justice Brennan, and they did a ton. I mean, so it's not like that was not a crazy thing after Brown v. Board and everything else in the 60s and 70s. What do you think about that today? Do you think that's not... Do we go back to a version of that, or is it more just the courts at least should get out of the way and let liberals govern?
Before he was president, Barack Obama, in an interview or two, sort of criticized his friends on the left a little bit for putting too much emphasis on the courts when it came to social justice, expecting too much out of the courts. I'd say that comes closer to where we are now. It's not so much calls for the courts to sort of get into the inequality fights, right? To somehow the courts would invoke the 14th Amendment or something as a basis for new law on inequality. Basically, I think the way they see it and the way they'll frame it politically is we need the courts to not do any harm to existing precedents of the last 40 years. So the courts should take a strong role in defending Roe v. Wade and so on. And the court should do no harm when it comes to experimentation at the federal or state level in the legislatures or in the agencies in creating policy. I'd say right now the real engine of progressive policy seems to me administrative agencies more than anything else. And so making sure that the courts stay out of the way of that, stay out of the way of legislatures, would probably be pretty key for them.
Right. It seems like that would be the liberal message. You elect me, my education secretary will insist on, colleges and universities behave appropriately in terms of Me Too related issues on campus and so forth, and diversity. And we're not going to stand in the way of colleges pursuing diversity in a good way. And our Justice Department's going to enforce the Voting Rights Act and not going to be on the side of litigants against colleges and universities to try to rectify historical injustices, et cetera, et cetera.
Right.
And more than I'm going to appoint judges who are going to, make, equalize wages across the country, right? That's more of a legislative or administrative agenda item, I guess. So I don't know, these things could change, I suppose, and a decision or two could bring things front and center.
They could change, and a swift change in the courts. If Hillary Clinton had been elected president and Gorsuch weren't on the court, Kavanaugh weren't on the court, two liberal judges were on the court, you could see them making some moves on this. But I say with the addition of those two young justices, it becomes harder to sort of formulate a policy of judicial policy making, and it has to be more of judicial restraint in the face of old precedents and new statutes and regulations.
Yeah, that's interesting. Absent, unless they really go all the way with the court expansion.
That's right.
And is that really the one main proposal? I guess it is. Some different versions of court expansion, right? Sometimes mandatory retirement ages, or 3 of them, or different ways of appointing them, or 20-year terms. But it seems like it's somehow or other to dislodge what they fear is a semi-permanent or a lasting, or at least lasting for a while, conservative majority on the federal courts up and down. And that seems to be what they're worried about.
Yeah, I think they're worried about conservatives having a court that the left had for the last several decades, right? Not extremely liberal, but reliably liberal on the issues that matter to them. I think that's what they worry about with conservatives, is not that the court is going to just become monolithically conservative. In fact, if you look at the stats for the last year, even with Justice Kavanaugh now on the court was often split. There are actually more sort of clearly, this is according to SCOTUS blog, the best website on these things, I think 45% of 5-4 decisions were really liberal outcomes, and far less than that were clear conservative outcomes. And it's not hard to see that continuing when you've got a reliable block of 4 liberal judges and the conservatives sort of splitting up amongst themselves in interesting ways. I'm going with this is, it's not, again, I don't think the left fears that the court's going to be monolithically conservative, but that it'll be reliably conservative on some issues that they care about, like abortion, like affirmative action, like skepticism of the administrative state. And so I think what they'll do is call for the court to just do less, be judicial minimalist. Minimalist is a term you often hear. I think that will be the way they frame it. And again, that's why I think if they wanted to pick their ideal justice, it wouldn't be somebody, a candidate wouldn't say Ruth Bader Ginsburg, even though she's a hero to the left and they make movies about her. And anytime she, has a health scare, the whole news media, everybody just stops dead in their tracks. For as much as they lionize her, I think politically the better character to look to is Kagan, who has been a little bit more moderated on a couple of things, who is, though, in general, pretty reliably liberal, who comes across temperamentally as very moderated. She's very sort of likable. I think that's who they'll sort of put forth as their ideal justice, in part because she is so deferential to, or she is more deferential to the political process in some ways.
I mean, this conversation is making me wonder whether you could also have the reverse almost, where conservatives at some point look up and say, this has been a lot of hoopla about Kavanaugh and Gorsuch, and it's all exciting, but at some point do we get a, conservative saying, as the author of the Flight 93 manifesto said, all these conservative victories were sort of meaningless.
Yeah.
Marriage equality is not going anywhere. Let's just assume for a minute, and I want to come back, maybe ask you about that, Roe v. Wade isn't going anywhere,
right,
if that were the case.
Right.
The administrative state isn't really going anywhere. Religious liberty, good, nice. Obviously it's great from the conservative pro-religious liberty point of view that, Orthodox rabbis aren't going to have to perform same-sex marriages if they don't want to. But at the end of that's more of a defensive, protective thing, and the culture could keep changing in the way it's changing.
Yeah.
And could you imagine that? I mean, in a funny way, Trump almost wins, let's say, gets reelected, and 2 years later, everyone's saying, well, that was all very nice, but that didn't really do what we wanted, done.
Well, sure. I mean, the judicial nominations are not always going to be front and center in our politics, and I hope that's the case, right? The presidential elections should not be an election to pick the person who picks the people who actually govern us, right?
Yeah.
That's not how it should be. I'd say in the short to medium term, I think that the court will remain front and center, in part because people can remember where they thought the court might go. But as we get further from that political moment, sure, maybe the court will recede in importance. But right now, I think, to get back to an earlier point, I think right now the intellectual energy among the conservative legal movement, which is not the same as conservative voters, is for courts to do more and more, for judges to do more and more. And who knows how that'll play out. It'll be interesting to see how that plays out. That could change the stakes of the political fight. I wouldn't make any predictions past 2 presidential elections from now.
No, even one.
Yeah,
Even zero.
but just even in terms of predicting the salience of the judges issue.
Right.
The memories of the most recent sort of judicial regime are too fresh, and we don't know what's going to happen in terms of how this current generation of judges is going to play out, or how the Democratic response is going to be.
No, and I actually was sort of going the opposite way from the way you took me. I think I wasn't clear, which is you took what I was saying, which is, let's assume Trump reelected.
Yeah.
Roe gets presented to the court fairly clearly, which could happen, right, in 2021 or 2022.
Right.
Maybe there's been a change in personnel and there's another conservative appointment even, and the court doesn't overrule Roe. At that point, I think you could have a situation where the scare of it being overruled has got the left even more up, obviously, in arms than they are today, if that's possible. And the right suddenly goes into a kind of, let's just making this up, obviously, in the competition to succeed Trump in the primaries, some people on the right are going to say, we didn't go far enough.
Right.
You know, we got suckered again by the establishment. And so you could imagine more polarization and more confrontation on the courts, even if Trump's reelected. And I think if a Democrat wins, and let's just assume, even if a Democrat doesn't seek to be particularly confrontational on the court, they're going to make liberal appointments, as Clinton did and as Obama did. And then issues are going to be close on some of these religious liberty issues and so forth. I mean, I guess I'm a little. It could be that the courts recede, which I think would be somewhat healthy. But I guess the more I think about the different scenarios, and of course they're almost an infinite number, so you can't really. Who knows how, which of these justices retire and don't, and so forth. I mean, you could write a lot of scenarios where they remain front and center in a way that might be unfortunate for our politics, but might just reflect a certain reality, right?
Yeah. I guess this is intriguing. Like the Roy Moore scenario, right, where he runs saying Trump was a wimp.
Right.
He didn't give us, and again, I pick Roy Moore not just because it's Roy Moore, because of Alabama, which has had some of the new restrictions on abortion.
I mean, what about Roe v. Wade? Because you mentioned, I think, in very passing, I probably took it further than you maybe intended, that you thought it seemed to me you said you thought it might not be overturned, or
I don't think
even if it were, that it leaving aside whether if it were, it would have what the actual real world effects of it would be. Do you actually think that that's the case, that even in let's say a court where there's another Trump appointee, you think that there would be a majority to contain it, I'm sure, constrain it in certain ways, but not flat out overrule the national right to
So here's why I'm skeptical that the Supreme Court's going to overturn Roe v. Wade. Let's just play this out. The first thing it takes is a state that passes a law that doesn't just sort of thoughtfully or cleverly, restrict abortion, but not sort of claim to overturn Roe. You need a law that actually gets passed and enacted in a state that cuts to the heart of Roe v. Wade. Then you need somebody to challenge that law who won't take it to a state court, right? Your first move might be go to a state court, the state Supreme Court, say this is so clearly unconstitutional, even under our own Constitution, right? They have to check that. Then they go to a federal district court that's going to almost surely say whether the judge likes Roe v. Wade or not. This is clearly against Roe v. Wade. And then it's going to go to a court of appeals, which is going to almost certainly strike down the law, because whether the judges like Roe v. Wade or not, if it's a law that so clearly cuts to the heart of Roe v. Wade, the lower court is not going to uphold the law. And that could be the end of the case. Then you have to get the Supreme Court to take the case. And it'd be one thing if the case got up to the Supreme Court and then they had to decide it. First, they have to decide whether they're going to decide the issue at all. And it's not clear to me there's the appetite on the court to take that. And I'm not sure if...
It takes 4 justices.
It takes 4 justices. And it's not clear to me that if the court decides not to hear the case, that the public would rise up in the way that sort of the worst case scenario would be. But in any event, the first step's the most important. I don't see many states doing these things that cut to the heart of Roe v. Wade.
See, I think the way you formulate it, which I think is very intelligent, and I agree with actually, I think is, if for some people would say that's itself very revealing that you're some kind of inside the Beltway sellout who wants to duck this controversial issue, which is really at the core of all the bad jurisprudence of the last 50 years, which isn't like a crazy point of view, maybe, or is it 50 already? I guess it is, almost 50. And they don't need to have a case that cuts to the core of it. They can have a case that cuts to part of it, and then just say, and incidentally, Roe was wrongly decided. There's no real basis for it, and this was only a 3rd trimester or 2nd trimester abortion case, or this was only a a various regulations case. But while we're at it, we're just going to tell you, you think there's very little chance, I assume, the court would reach to strike down Roe sort of gratuitously, given though people might urge it to, given the character of the Chief Justice and of some of the justices, or just the political constraints on the court? Or
Well, first of all, I'd say the scenario I sketched out, it's not just counting on like a wishy-washy Supreme Court. It's just counting on the fundamental moderation of the people in the states, right? It's that even the reddest of red states, the legislature is not going to go that far. They might aggressively regulate abortion in ways that tee up litigation, but even then, it's not going to go to the heart of the Roe v. Wade issue. And when a statute short of that comes to the Supreme Court, the justices don't need to reach the Roe v. Wade issue. That's like I think that this court will actually do a lot to uphold lower state laws that regulate the health and safety, the safety of abortions, the health of the mother, the health of the unborn child. They don't need to reach that issue, and institutionally, the court is moderated. It always has been, or it should have always been, by norms of not reaching issues you don't have to. And this is a place where the Chief Justice plays a big role, but the court as a whole, all of the justices, they're sort of in almost like I'd say this is one way in which the justices are still very Tocquevillian, whatever their political bent. Tocqueville said that judges would be moderated, they'd be careful in what they do and quiet in what they do. And for the most part, that is still true, at least when it comes to an individual case where the judges have to decide how far to go. Now, the last step is, of course, the Chief Justice. He has a real say in how far a court will go in a case. First of all, because this Chief Justice is the central vote, so he gets to pick what the majority is, whether he's on the right or the left. And then he gets to pick how broad the majority is, whether it's a 5-4 majority or a 6-3, 7-2 majority. And so he can moderate the court that way. And those two factors, Chief Justice Roberts' power to vote and his power to sort of assign himself the opinion or assign the opinion to somebody else, but in a way that he knows how the opinion is going to be calibrated. He has a real say in how fast the court's going to move on issues and how far it's going to move on issues.
And it seems to me what you're saying is that the Obamacare precedent of 2012 is to some degree going to be the future. That is to say, a court that doesn't quite go as far as it might in really making major decisions that would, on the one hand, please a lot of conservatives, but on the other hand, really disrupt either a bill that was passed after a huge amount of debate and signed by a president, or in the case of Roe, almost 50 years of precedent. And I guess some conservatives might say, really? I thought we were talking about, the courts is why I voted for Trump, and I thought we were really going to, change, get religion back in the public square, and I thought we were really going to address the administrative state, and I thought we were really going to deal with these issues and not just have a kind of John Roberts sort of statesman-like, Alex Bickle-like, I guess you would say, maybe, right?
I don't know if I'd say that, but
is that right? Well,
I wish I could say that. Yeah. I don't know that he's going to be Bickellian,
but I mean, sort of prudence and moderation on the court. I mean, do you think actually? I mean, I guess leaving aside what we would like, you think that's the more likely scenario, even with a preponderance of conservative appointees over the next, let's say, a couple of terms? Presidential terms.
The Obamacare case is the one that people think of the most. It's so controversial. But there are a lot of areas where the chief, and he's been chief now for almost 15 years.
Yeah, it's amazing. Yeah.
A lot of cases where he would start small and he'd assemble a broad coalition on things like interpreting the Voting Rights Act, on the collision of public sector unions and the First Amendment, and other areas where the first time that kind of controversy comes to the court, Roberts would assemble a pretty broad coalition to have a very narrow, sort of fact-based decision. And then maybe the issue returns again in a slightly more extreme way, and the majority gets a little smaller, right? And the court moves a little further, right? Roberts has done a lot of that. The Obamacare case, obviously, that's a big and controversial example. Even some of the little technical issues like the deference thing. When the Supreme Court, there was a case last year where it really went to the heart of how much deference agencies should get from courts. And Roberts ended up siding with the left. He assigned the opinion to Elena Kagan. She wrote a pretty moderate opinion, one that really lined up with the Trump Justice Department's argument, that sort of reformed the doctrine, moved it rightward. Not as far as a lot of people would have liked to see it go, but I think a good movement. Those sorts of cases, I think, are the way we ought to think about this. And it's not that Roberts is emulating somebody like some law professor like Alex Bickle, who, as you know, is my hero. It's more that the Chief Justice is acting like a Chief Justice in an era where, once again, a Chief Justice is in charge of the court. Rehnquist did this sort of thing sometimes. You look back, even look at somebody like John Marshall, who obviously was no shrinking violet, obviously had a particular direction he wanted to move the court in, but he was careful about how he did these things. He was careful to cobble together strong majorities, unanimous majorities when possible. That really is, if you look at the history of the court, the Chief Justice has often been, not always, but has often been a moderating force, even when the Chief Justice has a vision of where he wants the court to go. And I think it's something that interests me more and more, actually. It's the way in which, and we're all familiar with this Madisonian idea of ambition counteracting ambition, but the interests of the man being attached to the constitutional rights of the place. Nowhere is this more true than of a Chief Justice, more than any other justice on the court, more than almost anybody else in government, where with the presidency and Congress they identify with their political parties. The Chief Justice is in a position to more closely identify with his institution than anybody else in government. I think is in a position to not just form his institution, but be formed or reformed by his institution. Some would say deformed by his institution. And I think that's a dynamic that'll be very interesting to watch with the chief for the remainder of his term, assuming he stays in the middle of the court, and for his successor, whoever that'll be.
And conservatives who are watching this or listening to it and who are more ambitious for what a conservative court might do would say, well, that's just typical. The conservatives are going to be prudent and moderate and do step-by-step things, and the left, at the moment they get 5 votes, will do something huge like marriage equality. We want to do the same thing with redistricting, and we want to do the same thing with various issues of race, gender, equality, even administrative state, and working. We want to sanction states and maybe the Congress being extremely aggressive in some of these areas. And do you think the left also, in other words, if let's say there's President Elizabeth Warren and she gets a couple of appointments, and do you think they all? That would argue for a sort of a muting of the court wars. But it's not clear that the left is on board for muting. Some of the right may not be on board for it either, of course. Is the mainstream left even on board for this kind of
Probably not.
muting? They might be, in the sense that they don't think the courts are key to achieving their aims. They just need a kind of restraint by the courts, I suppose.
Yeah, I think so. It's in terms of Republican frustration. The downside of being a capital R Republican who believes in lowercase r republicanism is that you don't count on the courts to change the world. You count on the courts to maintain the ground rules for the political process and to protect rights, but to be mindful of the crucial but limited role of courts in our country. And so, if you're dissatisfied with that, I'm sorry. But I'll say Justice Scalia, I teach at the Scalia Law School, I teach a seminar on Scalia. And in the last class before this taping, we read one of his original law review articles where he has a line, he says, a cynic could say that with 5 votes, anything is possible. And he didn't say who he was talking about. He was talking about William Brennan. Brennan, the Eisenhower appointee, but swung hard to the left, famously said, with 5 votes, anything is possible. And that might be a Brennan-esque view of the world, but it's not a Scalia-esque view of the world, and Scalia was right.
Well, we'll see. He may have been right intellectually, but is that going to control the future? I guess. Well, finally, just close with that.
Yeah.
Let's talk about the right and the left in terms of the doctrine a little bit and the understanding. So originalism, you think, is the dominant strain among conservative constitutionalists and jurisprudence. And there'll be fights, though, about kinds of originalism and the extent of how much it overwhelms deference to tradition and so forth. And
it's a fight over it. All conservatives are basically now originalists of a sort. The arguments over how far should originalism go to trump precedent? When should to trump judicial precedents? When should originalist analysis sort of yield to established precedents and frameworks? The second way, and I think this is the interesting fight that's playing out now, is how aggressively should judges scrutinize laws passed by legislatures? Should they, again, force the state legislature to prove that a policy that's been enacted will actually solve the problem it purports to solve, and that it's narrowly tailored. How far also should judges go in reading into the 14th and 5th Amendments broad references to liberty, specific protections of economic liberty, and so on? Those fights, in some ways they're old, in some ways they're renewed again, and I'd say a lot of the intellectual energy on the right is in favor of the more libertarian approaches. But that really is the fight within the right. On the left, I think the best evidence of originalism's success is the fact that you see Justice Kagan and others say we're all originalists now, and that a lot of cases, of course, all cases are argued in terms of both precedent and text. I think you see a greater effort by advocates, even liberal advocates, to make originalist-ish arguments for their cases, and for judges to justify their decisions with a form of originalism. Of course, not quite the same as the right, and I think the left is much more eager to move to things like liberty protecting human dignity. That was a key buzzword in a lot of the marriage and gay rights cases, and in abortion it's about dignity and equality. But you do see a move to the left to try to in some ways claim originalism or a version of originalism.
And not so much of a full-throated living constitution. We have to adjust to the times. We can't be constrained by these people from 200 years ago when things were so different.
Or when you argue for what looks like a living constitution, you're framing it in originalist terms. The original understanding was that this part of the Constitution would evolve over time,
right,
and it would accommodate sort of the progress of human knowledge and the belief in human rights and so on. So I think that's the big fight. It would have been fascinating. I'm glad we didn't see it, but it would have been fascinating to see who President Hillary Clinton would have appointed, because it's not hard to imagine if they hadn't been chastened by the Trump election and the appointment of Gorsuch and Kavanaugh, how far left they would have gone to replace Scalia. Garland, he was not an ideologue. He was not a radical. I don't know if they would have, if Hillary Clinton would have nominated Garland or somebody like him. They might have picked somebody who looked a lot more like Ruth Bader Ginsburg.
Yeah, and finally, constitutionalism and all of this. I guess if one scenario plays out, you could argue pretty good, kind of a comeback for constitutionalism, right? That both left and right, in a certain way at least, are trying to appeal to the Constitution, respect constitutional norms, try to not break the bounds of the Constitution. But one could also imagine scenarios where it's sort of Trumpism on steroids on the right, and Bernie Sandersism. It is sort of striking. Are you not struck? And I'm not one who thinks the Democrats necessarily are going that far left, and you should take every campaign speech as gospel of what they're going to do.
Right.
Having said that, they are rather cavalierly promoting and promising things that are like a very questionable constitutionality, right? They're going to order the whole country to do this. They're going to have a mandatory buyback. Some of it is framed as congressional legislation, but some of it isn't. Some of it is sort of the executive branch is suddenly going to be doing all these things that, like, what law justifies that? And what about liberty rights? And what about the Second Amendment? What about other amendments?
Yeah, I'm not whistling past the graveyard here. I'm less worried about the court than I am about American constitutionalism in general. Oftentimes the people are a very moderating force on the court. Right now, I'm not sure. One of the things that, I've recently joined AEI, and our program is on it's social, cultural, and constitutional studies. And I like the way that Yuval Levin, my new colleague, has framed it that way, to remind us that it's not sort of constitutional law, in the courts, the exclusive property of the courts, but it's a constitutionalism that's rooted in our society and our culture. And I think one of the real costs of the rise of judicial activism and the Warren Court, for all the good that the Warren Court did on a lot of things, it really took the Constitution and made it something that courts think about, and made it sort of the stuff of political theory, of law school theory, but not something that's really rooted in the American people, and that the people themselves know they have to tend to, and that our leaders sort of remind the people that they need to attend to, that where our leaders, both, whether not just the president, but members of Congress, members of the court, in the way they go about their work, sort of exemplify the Republican virtues that we need for this whole framework to succeed, all the doctrines we've been talking about, they sort of rest on top of this much deeper sort of mesh of values. That's the real constitutional debate that we need to be having right now is our society sustaining those virtues and values that are necessary to make the court stuff work? So Yuval and I, my colleagues, will be busy.
You will be busy, and we'll see a lot. We'll learn a lot, I suppose, about the broader society and culture in the next couple of years on both sides of the presidential campaign and in Congress. And as you say, it's not just the judges who swear an oath to uphold the Constitution, right? I mean, every elected official, and in some ways every citizen, is supposed to be thinking in a constitutional way in some way, right?
I think it was Ralph Lerner years ago. He wrote that the early Federalist judges were Republican schoolmasters, which is a little heavy-handed, but the idea that the judges, as they rode circuit, right, and appeared in those days in different towns,
right,
they had an opportunity to not just decide cases, but in the way they went about their work, explain and exemplify the doctrines and the values that this new government, this new Constitution was supposed to embody. I don't like being lectured to by my government officials, but I think there's something to be said for demanding that the members of the court, the president, members of Congress, do their jobs in a way that not just make policy and don't just talk about these values, but actually exemplify these values, because it's the only way that we're going to sustain the foundation under the court and the rule of law.
I look forward to us reconvening in a couple of years and discussing both the narrower, and they're really narrow, issues of the court makeup and constitutional decisions and con law. But as you say, it really does come down to the broader questions of what does Harvey Maxwell call it, America's constitutional soul, really, and how does that stand, and how committed are we to it, and how well do we understand it, and so forth. So we'll have that conversation soon. But thank you, Adam White, for this conversation, which I found really instructive and thought-provoking, and I'm sure our viewers have done so as well. And thank you for joining us on Conversations.